Hi, and welcome to this short webinar which is aimed at explaining why a local authority may refuse to carry out an Education, Health and Care, or EHC, needs assessment, and also look at what options a parent, carer or young person might have. In order to understand why a local authority might refuse, it is helpful to know the legal threshold for an EHC needs assessment and explain what a local authority is looking for when they receive a request. This is outlined within the Children and Families Act 2014, which states that a local authority must secure an EHC needs assessment for a child or young person where the child or young person has or may have special educational needs, and it may be necessary for special educational provision or additional support to be made for the child or young person in accordance with an EHC plan. This test is simply whether the child or young person could possibly have special educational needs which could need additional support which goes above and beyond the resources and expertise which would routinely be available to a setting. So we're now going to look at what is expected of a setting before considering an EHC needs assessment. The law expects that mainstream nurseries, schools and colleges should use what is known as their best endeavours to make sure that a child or young person with special educational needs gets the support that they need. This means doing everything they can to meet children and young people's special educational needs. The law continues by saying that if despite evidence-based support progress is still not being made, then settings are expected to seek the advice and support of specialist services. The law therefore expects that the majority of children and young people with special educational needs will have their needs met through this special educational needs provision. When a local authority receives an application for EHC needs assessment, they will be looking for evidence-based records which clearly show that the setting is taking relevant and purposeful action to identify, assess and meet the child or young person's special educational need, and that despite this support and intervention, the child or young person has still not made expected progress. This should follow the assess, plan, do, review cycle. Further information on SEN support can be found on our websites. So now we're going to look at why a local authority might refuse a needs assessment application. So firstly, if insufficient evidence is submitted which does not demonstrate to the local authority what the child or young person's needs are and information regarding what the setting has already implemented to support them. Secondly, the local authority may decide that the setting have not yet considered and implemented all the options available to them to support the child or young person and that they should be doing more. Also, if support strategies or interventions have only just been implemented, the local authority may require this to be reviewed over a longer period of time to allow the impacts of these strategies to be identified. The local authority may feel that the child or young person's needs can reasonably be met within the resources available to the setting as well. When an EHC needs assessment application has been submitted, the local authority will have 6 weeks in which to make a decision whether or not to carry out an assessment. This decision notice should be given in writing and outline the reasons for refusal. The decision should also outline to a parent, carer or young person their right to appeal the decision, as well as providing information regarding mediation services for consideration for disagreement resolution. So what happens next? The local authority refuses your application for EHC needs assessment, you could consider sending further information or evidence through the local authority and asking them to reconsider their decision at the next panel meeting. You could allow some time to establish the impact of any early interventions and consider making another application again in the future if this is still necessary. You could contact the local authority to arrange to meet with them informally to discuss the decision or engage in formal mediation to try and resolve any issues. You could also register an appeal to the SEND tribunal. So what is mediation? Mediation is a less formal way of trying to settle the dispute between you and the local authority. It involves meeting between you, the local authority, and an independent mediator who will try to help you reach an agreement on the points of dispute. You will need a mediation certificate before you can appeal, and you can get this in 2 ways. either by undertaking mediation, and if it does not settle all of the points in dispute, you will be issued with a certificate confirming that you took part in mediation, or speak to a mediation advisor and you will be issued with a certificate confirming that you have been told about your right to mediate but you do not want to do so. Either way, you will need to obtain a mediation certificate before you appeal a refusal to assess decision. To do this, you will need to call the number provided by the local authority on the decision notice and request a mediation certificate. It is really important to note down dates and be aware of timescales and deadlines for making an appeal. Firstly, make a note of your appeal deadline. The date given on the decision notice will trigger your right of appeal. You must then send an appeal form to the SEND Tribunal within 2 months of the local authority's decision letter, or 1 month from the date you obtain a mediation certificate, whichever is later. If 2 months or 1 month ends in August, then you have until the first working day in September to submit the form. If you require advice and support with your appeal, we would recommend that you contact the SENDIASS services as soon as you receive the decision notice to allow sufficient time for an advisor to be allocated and help you. What do you need to submit with your appeal? So firstly, you will need to include the local authority's decision letter, which is a signed and dated letter from the local authority giving you the right to appeal. You will then need to include a mediation certificate, which is a signed copy after taking part or not. You will also need to complete a SEND 35A appeal form with your reasons for making the appeal. You will need to submit evidence documents to support your appeal also. Please be aware that you can add to this later up until the Tribunal's evidence deadline, so don't let this delay your appeal submission. A list of all the documents needs to be enclosed also with the application, and it will be helpful to the SEND Tribunal if you put all of your evidence in chronological order and then write out a list explaining what each document is. There are lots of useful resources which can help you with this process, details of which can be found on our website. Contact details for your relevant local authority SEN teams can be found here. Thank you for listening. Should you have any questions or queries, please feel free to contact us. Our telephone numbers are provided here, as well as our email addresses. There is also a web chat facility available on each of our websites. Thank you.